Hey guys, and welcome to today's video. Today we've got a longer one lined up, covering a sovereign citizen who finds himself deep in legal trouble over unpaid child support owed to his ex, and his excuse is something you really won't see coming. We're breaking this down into three parts: his pre-trial hearing, the full jury trial, and finally his sentencing. The original footage runs over 6 hours in total, so I've trimmed out the long pauses, silence, and unnecessary moments to keep only the most intense and, honestly, the most entertaining courtroom highlights. So with that out of the way, let's jump straight into it.
Mr. Howard, is that you back there, sir? Okay, 75 C01 2311 F6 157. So this got set by Judge Hall because I think you wrote a letter saying you were hiring an attorney, and he
there did no such thing, sir. It was about seeking counsel, which did not pan out, so I have to strike that from the record.
Okay, so you're not hiring an attorney?
No.
Okay, well, so I'll ask you here. Do you want me to appoint someone to represent you?
No.
Okay, so you're gonna still represent yourself.
Jury jurors, property of name.
Oh, okay, here we go with this again. All right, so let's just set him on the jury trial.
Why you say it like that? This whole thing's about Latin. All the laws are behind Latin. Why do you act like that's a crazy thing?
No, sir. So we've discussed this multiple times about the sovereign citizen thing.
It has nothing to do with sovereign. That's what I've been trying to tell you.
Okay. All right. Well, we've had this discussion before, and I've pointed out to you all the case law that says, there's no basis in any of those types of arguments. I don't want to keep getting this discussion over and over again. I understand that I'm never going to change your mind, but you're also probably never going to change my mind. So
that's not what we're here to change each other's mind. We're here to follow the law.
That's why I'm setting it for trial.
It is.
I already got the trial. Everything's already set.
Okay, so he's already set.
It's set for trial December 17th at 9 a.m. And I don't know if you have jury status.
December 20 or 19th or 17th, something like that.
December 17th at 9 is the trial, but
Let's just make sure we get all the dates right.
making sure I don't have a jury status. But
And I want to make sure we're here because, if you need me to appoint someone to represent you, I will.
I do not.
Okay, because that motion you filed October 8th makes it sound like you were wanting an attorney. I just want to make sure.
I was thinking about it, and then you continued anyway, so it was already continued. It didn't have nothing to do with what I filed.
Okay.
yeah,
That's
jury
fine.
status December 3rd at 1:30, and then jury trial December 17th.
Is he set by himself on the 17th, or is there someone
He's set by him.
He's set by himself.
Yes.
Okay.
He is set by himself.
I know you've been congested before, so there's no one else set there. So that means you can't get congested. So either the state is going to put on evidence and prove something beyond a reasonable doubt, or they're not, and you're going to win, or the state's going to dismiss it, or maybe you'll file something and ask for it to be continued. I don't know, but we've tried to set it in such a way where there's no way you can get congested. So that won't happen again, because I think you've been congested, twice?
This has been going on since December 17th last year.
Okay, maybe 3 times, I don't know. All right, so is there any other record you want to make?
Filed some today, and we're going to go with that.
What? Did you file the same thing you filed before?
No.
No, is it
3
slightly?
times it's already in law. I already filed it 3 times.
Okay.
That's already law.
All right.
Now I filed something else that we can all agree upon. There's no sovereign nothing in it. It's all about equity. That's
Okay.
all. Trying to get this court back to private equity.
You understand this is a criminal case, right?
I do. But I also understand equity trumps.
Alright, so that brings the first hearing to a close. And as you've seen, this is a courtroom where the judge is clearly not entertaining any sovereign citizen-style arguments or off-topic legal theories being thrown around. To set the stage properly, the defendant, David Earl Howard, is currently facing over $24,000 in unpaid child support owed to his ex-wife, which is a significant debt that's now front and center in this case. With that context in mind, we're now moving into the jury trial, starting with voir dire, the jury selection process, where things already begin to get interesting as the defendant attempts to navigate the proceedings in his own way, and the court works to keep everything focused, structured, and under control.
Good morning, y'all. How you doing? So, I raise the hands. How many people know about the Bill of Exchange Act? What act? Bill of Exchange Act. Like the no hand raised. All right. Has anyone, with the show of hands, has anyone ever heard of the 1933 Emergency Banking Act? You know they're not going to have any of that.
So you're not doing
voir dire.
voir dire.
No hand praise on that question. Has anyone served in the military? Your hands. What was your name?
Tim?
Tim? Dykes?
Yes.
What was your name? Gilmore? Gilmore? Okay. Well. Anyone been through trial before? Raise your hands. Okay. No hands raised. What's that? Any trial. That, how did that go for you in your opinion?
Okay.
The court. It's been a while. So do you think you could be partial in this your trial, even with our whatever, a long history as a younger child for me? Think you'd be partial in the trial, or you think your health issues are gonna be too much and would you like to go?
Part of me says yes. I think I could be okay with it. I'm not 100% sure about my health side of it, but I can be fair about it.
Get that. Number Has anyone ever heard of show of hands? Anyone ever heard about any act involving taking over your minor account? There's a lot of acts that are not privy to the public, so it's making this very difficult.
Mr. Howard, you want to direct their comments towards doing voir dire and towards them, okay? Do you want to, Mr. Pullis, come here for a minute. Mr. Howard, come here.
Out of all there was 4 or 5 of you that have had child support, were you aware that basically the state is already funded for that and then you pay again second time? There was double dipping going on the whole time you pay.
But Your Honor, is this a question or is he?
Are you aware of that? There's double dipping going on. They're paying child support. No, that would be a no. Okay. Yes.
Oh, so Mr. Howard, again,
that would be all the questions.
okay.
All right, so that wraps up the first round of jury questions. And honestly, it raises some eyebrows, because instead of sticking to straightforward jury selection topics, there are moments where things drift into discussions like the Bill of Exchange Act and the 1933 Emergency Banking Act, which don't really have anything to do with the core issue at hand, which is whether child support was paid or deliberately not paid. The judge still allows a second round of jury selection, but it doesn't really change much, since the same line of questioning just gets repeated without much progress. So with that said, I'll skip ahead past the repetition and take you straight into the opening statements where things actually start moving forward.
How y'all doing today? So I got the same pretty much question as before. Does anyone with show of hands heard of the Bills of Exchange Act? That is a no hands. Right. Has anyone served in the military here? Has anyone ever heard of Trading with the Enemies Act?
Say that again, please.
Trading with the Enemies Act? That is no. Put that in with me.
But I believe at the conclusion of this trial, you will see, based on the testimony that you hear today, that I have met all those elements and overcome my burden to prove that David Howard, the defendant, did fail to support his dependent children beyond reasonable doubt. Thank you.
Mr. Howard, would you like to give an opening?
Yes. I am David Howard. I'm a veteran, diagnosed PSTD in 2008. Been working on and off different jobs. Can't keep nothing crazy like down. And I started watching my kids at home. I have a 5-year-old, 4-year-old, and a 1-year-old. I started watching them on my own because I couldn't say wow in public for a long time. I'm just now getting over that. Very hard. Why I stutter right now, because I'm still not used to being out in public. It just more messing me up a little bit. So the state says they intend to show that I did not, or that I willingly did not pay child support, which is incorrect. It is a provable fact that I was arrested multiple times, bonded out, and they held my bond for years plus instead of paying my child support. That's a provable fact. I have it on the record. So they kept doing it. It was over months at a time. Every day I'd go to, or like every other week, I'd go to walk my dog and I'd get picked up. If anytime I went willingly, yes, I know I'm working, I'm trying to catch up on the child support. They put in the bond, I'd eventually get out, a day or two later, and it would happen again. Then that's when I really started sitting down, understand our actual legal and money system. I found some discrepancies when I learned as a kid. Today, I plan to present you the actual facts in case law, in law, that what I presented to them as payment was in fact the debt was dissolved from then on. So I've done it 4 times now, and they have not accepted any of my legal tender payment. So you're here today for me to present yet again myself as a non-combatant towards the United States of America. I am peace and friendship, United States of America, which is the country we live. I will present that to you all your time.
Let me get this straight. Your argument is basically that you discharged the debt using your own version of legal tender, not once, not twice, but 4 separate times, and the state still didn't accept it as payment. And I hate to state the obvious here, but if it didn't work the first 3 times, what exactly made you think the 4th attempt was going to suddenly change anything? Anyway, moving forward, we're going to jump into some of the testimony next. I'm not going to include the prosecution's full questioning of the first witness, who is the mother of his 3 children. She explains that the children live with her, that she's received child support inconsistently over the years since the divorce, and that the total amount currently owed is now over $24,000. With that established, let's go ahead and move into his cross-examination.
So, Jamie, where's Lily Eaton living right now?
In Warsaw?
By herself?
Yes.
She has a what?
A baby?
She is supporting herself as a grown woman, right?
Yes, she is.
Hunter, he's still living with you?
Yes, he is.
Time?
Yes, he is.
So when they were born, where was I?
You were in the Army.
When I came home, what happened?
What do you mean?
When I came home, what would happen? When I come
You
home
would-
and leave,
You would see him.
just see him. I didn't have him, never,
They might have stayed at your dad's house, yeah, a couple times. Yeah. But
way more than a couple times. And you know that, we both know that. Okay, I seen them a lot more when I was young, when they were young.
Jack.
Okay, so Mr. Howard,
Okay, I'm sorry.
Wait, just hang
sorry,
on.
y'all. I will get into a ramble.
just listen to me for a second, okay? So this is your opportunity to ask questions. So wherever you're saying is in with a question mark. If you want to present evidence and give your sides, you got to be under oath, and we'll get to that point. So keep it to questions, okay?
are you aware that I was diagnosed with PTSD after getting out of the military?
No.
How long has Lily been out of your household?
Not even a year. A little less than a year.
My absence has pushed me and them away from each other. So as in communications has pretty much non-existent. So my absence as in being in the military, being out on PST, PD, whatever, not being able to communicate with the world. Do you think that has affected our communication as in your and I, mine and the kids?
Yeah, I'm not really understanding, I guess.
If you don't understand the question, just say you don't understand it. He can ask it different.
Okay, I don't understand.
After my time served in the military, when I came home, was I the same person?
I mean, no. I don't think so.
Question, John.
Redirect.
Jamie, were the children living with you back in 2023?
Yes.
And that would be Lily and Hunter?
Yes.
Question, Jamie?
So on that one issue, you want to do any recross for Howard?
Mm-hmm. Did Lily come stay with me during that time? This was when I was still in Stark County.
That's which time?
Well, you said in July of 2023. He said during that time. So he's referencing July of 2023 is how I interpreted the question.
Yes. I don't know when she stayed with you, really.
Let the court reflect that, yes, at that time she was
Mr. Howard,
thankful.
her answer is her answer. Okay, they heard her answer. Okay.
All right, so that brings her testimony to a close. And honestly, it's hard not to feel some sympathy here. Not just because of the unpaid child support, but because she's had to deal with the aftermath of a situation that clearly hasn't been easy. Next up, we skip over the following witness, a caseworker who simply confirms the existence of the child support order and the total amount owed, which is straightforward and uncontested, and he doesn't even attempt a cross-examination. After that, the prosecution rests their case. And now, the big moment arrives for the defendant. He has to decide whether he's going to take the stand and testify or remain silent, which is always a critical turning point in any trial.
All right. So the state has rested their case. Do you have any motions to make?
Motion to dismiss. On the fact that legal tender has already been presented multiple times. If this goes any further, this is grounds for suit. This is grounds for definite appeal, winning, then coming back for a suit. You understand? I'm not going to play anymore.
Okay.
I went a whole year tendering payment multiple times.
All right. So is your only motion you're going to make a motion to dismiss?
Motion to dismiss on grounds of, I could do a lot of things, but I'll just say motion to dismiss on grounds that tender of payment has been made.
Okay. So you got to remember, I have to decide whatever motion you're going to make based on the evidence already presented. So let's hear the state's response to that.
Your Honor, there is no record of payment that's been already testified to. That he missed payments, that is arrears, is that,
I never said
what, Mr. House?
tender wasn't
Mr. Howard,
permitted.
Mr. Howard, let Mr. Pullis respond.
I don't know. Okay.
It's okay. Your Honor, evidence has already been heard that he is in arrears, and that he did not make payments through certain dates that were already testified to by Mr. Taylor. Regarding this dismissal on legal tender, I'm not sure what he's arguing for.
Okay. All right. So look, motion to dismiss is not really something I can grant at this stage of the proceeding. Really, what the question is whether or not the state presented, even a scintilla of evidence on the elements, and is there some of that? Sure. You're going to have, and this is why I need to give these advisements. This is what I'm going to go through. So that request that you made is denied because, we heard identification, we heard venue, we heard some vague reference to you not making payments, but then also making payments. And then there's this issue of whether or not, I guess, support was provided and whether or not the child was dependent. I don't know. That's all questions for the jury to decide. Just wait a minute, let me get through this. So that's argument you're going to make at close, I assume, based on the elements and the instructions. I need to give you this advisement. You've heard me go at this ad nauseum about you have an absolute right to remain silent. You don't have to testify. You don't have to do anything. This is the point where I have to say, hey, when we come back from lunch, you're going to have to make that decision. And this is a decision you make personally, whether you want to testify or you don't want to testify. If you testify and you have what are called crimes of dishonesty that are impeachable convictions, so in other words, like a theft or a conversion, shoplifting or something that happened within the last 10 years, you getting on the stand may allow the state to ask questions about those convictions. Do you know if you have any of those types of convictions?
No, I do not.
You don't know, or you don't have any? You don't have any. Okay. So I guess I need to know from you, do you want to tell me now whether or not you're going to elect to testify, or you want to tell me when we come back from the lunch break?
I'm still mulling it over, but I have a question for you.
Okay.
Has the defense provided any intent for this said crime?
I don't know. You're the defense, so that's really a question you'd have to answer. But if I had to make sense of what's been said so far, it does look like you arguing that the debt was somehow wiped clean through your own paperwork and filings, which the court clearly hasn't recognized as valid payment. And even if we assume you are genuinely misinformed about how any of this works, the problem for you is that it still comes across as a deliberate refusal to pay legitimate child support owed to the mother of your children.
Sure. So you're asking me in my finding, did I find that they prevented some sort of evidence as to whether it was knowing or intentional? So they've actually charged, I believe, knowingly if I look at the elements. So under Indiana law, knowingly means you're aware of a high probability of what you're doing when you do it. And so the question is there some information there where the jury could draw an inference that you were aware of what you were doing when you did it? I think that there is, but you're talking, look, and this is what I'm getting to. We got to talk about instructions, and you seem to be raising this issue of not having the ability to pay. I'm not sure exactly what you're saying. There's an instruction for those types of defenses, and I need to talk about final instructions. So that's why I'm asking you about the testify thing, right? If you're not going to testify, we can finalize instructions now. If you are going to testify, maybe I need to wait because it may change what instructions I give. And so let me ask this, does the state have any proposed instructions I need to know about now?
No.
How about you, Mr. Howard? You probably don't have the ability, you don't know, right? Or
I already got, you guys already got my instructions loud and clear, black and white. Bond order.
okay. But you don't have any jury instructions. That's what I'm asking, right?
Oh, no.
No. Okay. So what do you want to do about telling me whether or not you intend to testify? You want to wait till after lunch or you want to tell me now?
I mean, I think, yeah. I don't know. I don't see why not. I'm the only one who can speak for the living man because I am he, the living man.
So you're going to testify?
Yes.
Okay. So I don't know what you're going to say. The state doesn't know what you're going to say. So we're going to wait and do the instructions until after you're done testifying. Do you plan on calling any other witnesses, or is it going to be you and then that's it?
Emily wanted to, but I don't know. I don't think I really want to involve.
Well,
And obviously, I already told the jury I have my own other kids besides the two that are.
sure, and if you're going to testify, you can tell them that. But you got to understand this. You're going to testify. You're going to get treated like any other witness. There's two instructions, and this is why I'm kind of going through all this now. There's an instruction you didn't testify, and they can't consider it in any way. And there's another instruction that says you testify, they're to treat you like any other witness. That also means Mr. Poulos is going to cross-examine you like any other witness. But I need to know this from you, right? How do you want to do your testimony? Do you want to ask yourself questions? Do you want to testify in narrative form? What would make you feel more comfortable?
It'd probably be more like the narrative form.
The narrative form? And you have a problem with that, Mr. Bullis?
No, Your Honor.
Okay. So if you're going to do it in narrative form, I'll swear you in, and then I'll just explain to the jury you're going to testify in narrative form. I'll let you go. When he objects, you got to stop, though, and then we'll deal with what his objection is. And obviously, don't try to talk too fast because it's going to be hard for everyone to follow. And if there's an objection, you need to stop. We'll talk. You'll come up here. You'll get up off the witness stand. You'll come up here. You talk to me with Mr. Pullis. We'll talk about the objection. Then you can go back. Okay. All right. Anything else from you, Mr. Pullis?
No, Your Honor. Thank you.
Mr. Howard, how about you? Okay. Well,
So you're not gonna dismiss?
That's a hard no. Ghost Rider. Unless you suddenly produce actual proof of child support payments made in real legal tender, that argument isn't going anywhere. And since there's nothing like that on the record, the judge isn't about to dismiss the case based on that theory. But now we're getting to the most interesting part, his narrative testimony, where he finally gets to present his version of events in full.
is in here. So first, I didn't see anything you need to raise before we bring the jury back in, Mr. Pullis.
No, Your Honor.
Mr. Howard, how about you?
I still believe this matter should already been solved before I walked in the door today. So I'm still objecting to the non-dismissal.
Okay. And that's all on the record. That's fine. So we'll now begin with the presentation of Mr. Howard's case. Mr. Howard, would you like to call a witness?
No.
Or do you want to testify? You call yourself as a witness?
Yes.
Okay. All right. So come on down here, sir.
So, in testifying, I mean, do I get to talk first, or do I testify then talk, then have like a discussion?
I'm going to swear you in, and you said you preferred to testify in the narrative, so that's what I'm going to allow you to do. If you want to offer exhibits, they have to be marked, and my court reporter can give you stickers to mark them. So the state was marked with numbers, so you'll mark letters starting with A. You need to explain what it is you're offering. Let the state see it, ask for it to be admitted, and then we may have some discussion about it. But you're going to start by coming down here to the witness stand. I'm going to swear you in. You swear or affirm under the pains and penalties of perjury, any testimony you give today will be the truth.
I affirm.
All right, have a seat. So you said you wanted to do narrative, so that means you're kind of running your own show. So start just by introducing yourself and then saying whatever you're going to say.
I am David Howard. Currently, this case. Okay. The state says that they're going to prove that I had intent to not pay child support, but that never reached my mind at all. I've had 3 kids in 4 years, and I've had issues with working. I've had issues with leaving the house. So it's never entered my mind as an intent not to pay them or not to support them. Because I had a lot of things going on in my life, mental, emotional, new kids coming in to my life that threw me for a loop at 40. So yes, I've had issues. I never said the debt was not mine. All I'm stating is I never intended to harm or not support my older children. And what I brought up with their mom was my daughter has already had a baby of her own and living on her own. She's already essentially, in the law's eyes, emancipated herself. So getting back to the payment, I've already made legal tender at least 4 times in 4 different documents, 2 1099As, which on the 1099A it says who should use these. It says courtrooms, courthouses should use them. I've already offered the tender payment multiple times.
Exactly how much superglue have you eaten in your lifetime? Because you don't get to just redefine what legal tender means on the fly. That's already established under federal law, specifically Title 31 U.S.C. Section 5103, and it's pretty clear about what counts as valid payment in the United States. So unless you are paying child support with actual money that the rest of the country recognizes as legal currency, Then from the court's perspective, you weren't really paying anything at all.
So today I'd like to I asked you all at the beginning if anybody ever heard of the Bills of Exchange Act. Well, I asked that for a reason, because that is legal tender, which I had made at least 4 times. So I'm gonna read you a little excerpt. Under federal law, bills of...
It's evidence or?
This is just me talking.
Okay. So, well, you're reading something, so it's not just you talking. So you're
Just a lot.
you're reading something in the evidence. So come here,
Yeah.
bring it up here.
To approach this at a different angle. So, everyone here, we've all went to some form of schooling, right? Has anyone ever wondered why the legal system is not discussed in school?
Objection, Your Honor, he's asking a question.
That's just a question for them to ponder.
Mr. Howard, don't. This is you testifying. This is not you talking.
Excuse me, y'all. I'm frustrated a little bit, but okay. So the Bills of Exchange Act was put in 1846.
Your Honor, what is the relevance of the Bill of Exchange Act? No foundation.
Right. So, listen. So I'm just going to say this very succinctly to let you come up here, just because I don't want to. Unless you want to come up here, sir. I don't want to slow you down, but I'm going to sustain the objection for the reason I stated up here. I shouldn't have to something different. Okay.
Sustain. Yes, I got you. So, Senate document number 4373, Congress. The ownership of all property is in the state. Individual, so-called ownership.
So,
You know I'm gonna win on appeal. You keep
well,
being biased to my argument. My argument is
Mr. Howard, come up here right now.
We're gonna have King read for.
At this point, the judge has to excuse the jury from the courtroom because the defendant begins to lose control, and the court is careful not to let any outburst unfairly influence their perception of the case. Once the jury is removed, the judge addresses the situation directly to restore order before proceedings continue. After things are brought back under control, the jury is eventually brought back in so the trial can move forward.
This is going to be your one warning, okay? So I don't want to do anything that I don't absolutely have to do in this type of situation, but I have the ability to hold you in direct contempt of court. You're getting very close to that. I understand you're getting frustrated and you decide to represent yourself and it's not going the way you thought it would. Just listen to me for a minute, sir, okay? If I find that you're in direct contempt, okay, you can serve up to 6 months without day-for-day credit. So that's half a year you're going to sit in jail because you decided to act foolishly here in court when it's totally unnecessary. I do not want to do that, but if you force me to do that, that's what I'll do. You also don't want to behave like this in front of the jury. That's why I sent them out, because they're not going to interpret this positively towards you when you're behaving this way. That's why I sent them out of the room while you were having this outburst, so you wouldn't inflict unnecessary injury on yourself, right? You were doing just fine until just a minute ago, and then you lost your temper. I understand you disagree with what my rulings are, and that's totally fine, and you can disagree with what those rulings are, but you're not going to sit here in front of the jury, in front of the other people, and somehow imply that I have some bias against you when I have done nothing but been over backwards to make sure you have a fair opportunity to present your case. Not only that, you're precluded from making those types of comments in court. If you're a lawyer, you would have a real problem. You're more than welcome to have an appeal if you are convicted. We haven't even gotten to that point yet. If you win, you don't have to worry about an appeal. If you are convicted, you'll have a right to appeal. And if you want an attorney to conduct that appeal for you and you're indigent, I'll give you an attorney to do it. That's not a problem. You need to understand bias is not ruling in your favor. Bias is not shown just because I ruled against you. I'm ruling against you because it's not your job to read to them what the law is. They're here to decide a very narrow issue, whether or not the state has met the elements of the crime that they have charged beyond a reasonable doubt. I'm more than happy to let you talk about whether or not you believe you've made payment, and then the state can cross-examine you on it. but I'm not going to let you read off a bunch of random statutes off a piece of paper that I don't believe are applicable to this case. When we get to the instruction phase, like I talked about earlier, if there's some law that you believe is pertinent to the jury's decision of this state criminal matter, I'll instruct them on that law. But it's not your position, your purpose in this case for you to instruct them on the law. Do you understand that?
How are they supposed to understand where I'm coming from if I don't show them my findings?
Sir, you can tell them you think you've paid, right? I mean, that's what I tried to tell you when you're up here. And you won't just come out and just explain to them what your position is, will you?
I already told, I thought I told them I've said that multiple times. I've paid made legal tender multiple times.
Well,
and then when you get to the legal tender, then it also says stuff about once legal tender has been made, the debt is canceled.
sir, okay.
So that they need to understand where I'm. Laws on.
And I'm trying to make sure you understand this so we can get over this hump. You're trying to make a legal argument, right?
I mean, it's not. I guess yes. Yes.
We're at the part where you're supposed to give facts.
Yeah.
Are you giving facts?
They are facts.
No.
Are they not in law? Facts are not in law.
No, sir. Facts. So that's totally different. We're talking about what happened, when it happened, why it happened. Okay, that's where we're at. So that's what you need to focus on. And you can make your argument to me about what we need to have in the instructions when we get to that point. But I need it to be real clear to you that everyone has a role in here, and I'm doing everything I can to make sure you have a fair opportunity to be heard and to present whatever defense you have. But I'm not going to let you call into question my intent, especially in front of the jury, when I've done nothing but make sure you have a fair opportunity here. Do you understand that?
I do.
So we're going to have any more problems? No?
I
Okay.
understand.
All right. State anything else?
No, you're gonna overstand.
Okay. So let's bring them back in.
Before we get back to the trial, it's worth pointing out just how unintentionally funny that moment was when he first says he understands and then immediately tries to correct it to overstands. That kind of self-styled language might sound meaningful in his own framework, but in a real courtroom it doesn't carry any legal weight or change the meaning of anything being discussed. Whatever quantum grammar he's trying to apply here simply doesn't hold up in actual legal proceedings, and it certainly isn't going to influence how the judge or the court interprets the case.
Jury's back in the courtroom, and after that brief recess, we will now continue with Mr. Howard's testimony. Please retake the stand, sir. You're still under oath. Did you need to bring in your... I didn't know if you forgot if there's anything you're bringing up there or not.
Get my papers back.
Excuse me?
I can talk with my papers in my hand.
So,
Okay. Sorry, members of the jury. My mild outburst. You guys have to excuse me. Still deal with, issues from the past. Okay. The charges of intent to for their non-support is all-out farce. I mean, I paid for 20 plus years and never had any issues except for when they started stopping me regularly and arresting me. Then I started looking into all the court system, the banking systems, and once you look into that, there's a lot of stuff out there that honestly I couldn't believe I was reading it the first 3-4 times I read it. So once I got a grasp on the bills of exchange, I wanted to set off the debt so my kids can get a nice little chunk, and so I could, they can move on with their lives. They're older now. I want my daughter to be able to, do things for her young daughter.
So ever since then, I've been really trying to interpret all the stuff that we were never taught in school. It's it's a foreign language basically to us going through regular school, and it definitely, it took me by surprise, the knowledge that I learned from just reading some of these acts. Like our own Constitution is it's not a Constitution to restrict us. It's a Constitution to restrict the government from overstepping on our personal rights as individual beings. And I believe they were stepping on my rights every other week, arresting me, taking all the money I had, then telling me I still got to pay child support, or they're going to arrest me again. And it got to me where I could not handle it no more. And I really had to sit down and go through all the laws. And I found out that they have been overstepping, or not exactly allowing us to understand what's all behind these laws and these rules and regulations. So once I figured they weren't following their regulations, then I need to figure out how to go about it in a way that it's not taken from my 3 kids already, my 3 young kids that I just had, compared to my 2 older kids. So I went and read the Bills of Exchange Act multiple times, and I figured out that is the way I could set off my debt, make my kids okay and myself okay without having to take from my 3 young ones. And that's what I did. I put in multiple bills of exchange. They were all ignored. And in the own Bills of Exchange Act, it says any
Ejection.
He's starting to try to state a statement of law, but he can't do that at this point in time, Your Honor.
Oh, so I it's okay. I'll change the question.
Okay.
So, in learning this, once you have tendered payment, set off is complete. No matter if the intended trustee accepts it or not, by law, it is set off. So there is 0 money owed to the Stark County Circuit Court child support right now. There's 0 money owed. But now, yet we're still here in a trial for something that is already zeroed out. It makes absolutely no sense to me why this is being perpetuated. There is 0 balance on my child support. There's a 0. There's no reason for us all to be here. But yet, we are still here for a crime that was never happened. It was never intended to be a non-support by me. It just compounded life events stopped me from really going out and being able to work and do the things that I should be doing as a 40-year-old man. And there's no excuse. I knew that things were adding up, and I did all I could. I wrote a bond for this case, bonding everything. The bond is in place. My case number, calls number is zeroed out. I don't understand why we're here, y'all. I'm sorry to waste you guys' time today, but I appreciate y'all being here. That's all I got.
You're a complete idiot. Do you really think you were acting in your other children's best interests when you tried to wipe out your child support debt because someone online told you that filing a bond on your case number would make it disappear? I've seen plenty of wild theories in my time, especially from sovereign citizen-style arguments, but most of them end up only hurting the person using them. What makes this situation stand out is how it appears to be extending that harm beyond just the defendant and into his own children. At the same time, he keeps insisting that everything he's doing is to avoid taking resources away from his other 3 children with a different mother, which only adds more contradiction to his position. With his testimony now concluded, it's time for the prosecution to begin cross-examination.
Mr. Howard, you were aware that you had to pay $110 a week in child support, is that correct?
Yeah.
I'm sorry.
Yes.
And you knew you needed to pay that child support for Hunter and Libby Eden?
Yes.
And you knew that if you didn't pay the child support, you would gain arrears. Is that correct? And as of July 7, 2023, you said you acknowledged the debt, so you acknowledged that you were in arrears of $24,263.30. Is that accurate?
Mm-hmm.
And you didn't make payments, so that's how you got in arrears. Is that accurate?
Negative.
I'm sorry.
That is not true. I got in the rearage after
So
going to jail.
So you didn't make payments, accurate?
That is not accurate. I was working. You guys put in an order to my company to pay the child support. I did not know it was not getting paid. I have no control over that.
So then you didn't make payments, and that's what resulted in arrears. Is that correct?
I just stated I was working for a company, and you sent their order. I did not know it wasn't getting paid.
Stop. Mr. Poulos, you're asking a question, you're not letting him answer it. So let him fully answer the question so you can understand what he's saying. So say it again, because I think it's unclear exactly what the full answer is. Go ahead. Go ahead, Mr. Howard. Answer the full answer.
Full answer. Yes, I did not know. I realized I was in the rears until after being picked up, when my company said they have an order to pay the child support and they were doing it. I did not know that the office lady did not make the payments yet. I had no clue. I got arrested, bonded out, and then went back to work. The next week, got arrested again. Could not get bonded out by my company anymore, and they stopped paying the child support. That's the whole lot of things happened then, but I did not realize I was in the rears until it was already too late, and I was already way in the rears. That's why I said there was never any intention not to pay. I just didn't realize how big it had gotten, the rearage.
Well, it's your responsibility to ensure that the child support payments were actually being made through your employer. But something you just said really raises an interesting point. How would you feel if it was payday and instead of receiving real money you could actually use, your employer just handed you a copy of the Bill of Exchange Act and told you your wages were settled and the debt was cleared?
Now, Mr. Howard, you would attend those child support hearings. Is that accurate?
Which ones?
The one under the JP calls that you referenced?
Yes, I've came to a few.
Right. And they would make you aware as to what your arrears was when that would happen? When you'd be at those hearings?
No, I never went to any hearings. I always bonded out, or I got bonded out 2 times. Or I had to bond out twice.
So you're claiming that you never went to a child support hearing ever?
Not until December of last year.
December of last year in 2024?
Mm-hmm.
So you weren't in court on April 2nd, 2024?
I don't recall that date.
And you don't recall what happened at hearing?
When is that the 2,500 bond one?
No.
Oh,
That was in reference to you being ordered to just pay an additional $25 towards your arrears.
Oh.
It stated you were present there.
Mm-hmm.
Are you testifying now, Mr. Poulos?
No.
Okay.
I do remember.
Stop. There's no question. Y'all just try to follow the rules. Everyone just.
I don't have any questions, Your Honor.
Yeah, so now we go to redirect, Mr. Howard. So this is where you have an opportunity to say things in response to what you're asked on cross-examination. So would you like to respond to anything you're asked on cross-examination?
I mean, really, no. I mean, I got nothing for that. Yeah.
Okay. All right. So then I want to make sure. So that's going to be the end of your testimony, right?
Well, can I speak now, or do I got to get questions still?
Well, so if you do not take your opportunity for redirect, are you going to recall yourself? That's what I'm just saying. So we're going to try to wrap this up if you're done. That's what I'm trying to understand. Are you done?
Do I need to read this bond order out? Or is that, it's already in record, correct?
Sir, I can't give you legal advice. You know,
All right.
here's what I'll tell you. If you want an opportunity to kind of wrap up, maybe there's some things you forgot, I'll give you that opportunity, and then I'll let Mr. Poulos cross-examine you more if he needs to. But I'm just making sure you understand that once you pass here, you're done.
Okay.
And so that's what I'm trying to make clear.
Okay. I, David Earl Howard, accept the oaths of office of all judges.
Oh, brother, this idea that a judge somehow needs your acceptance of their oath just doesn't hold up in a real courtroom. Judges are already bound by their constitutional oath to the laws of the United States and the state they serve, and that authority isn't dependent on a defendant agreeing with it. At one point during the proceedings, the judge briefly pauses the trial to clarify what the defendant thinks he means by verbally accepting or challenging that oath, simply to keep the record straight and maintain control of the process. Once that's addressed, the trial continues, and the defendant is allowed to proceed with his line of argument for the sake of the record, not because it changes the legal standing of anything in court.
How you guys doing? Sorry, I don't do this every day, so still getting used to the intricacies of it. So this is a bond that I drew up myself after learning about the bills of exchange, the 1933 Emergency Banking Relief Act, the lending with the Enemy Act. So I learned a lot of things, and I put this together in order to secure all the parties involved in this court case. So I'm gonna go ahead and read it to y'all. It's a lot easier.
Remember, what exhibit is it?
This is Exhibit A for the defendant.
And you want to read it to them rather than having them read it? I'm asking you.
I don't know. Would y'all rather me read it to you, or you guys want to just read it?
Questions. You tell me. You're the one presenting the case. What are you going to do? You going to read it to them?
I'll read it.
Go ahead, read it to them.
I think it needs to be an open case, or on the open record.
It really doesn't change anything in a courtroom setting. But arguments like these often don't gain any traction in legal proceedings, which is why they are generally not taken seriously by the court. Still, they tend to result in a lot of extended explanations and repetitive claims, as the speaker continues to push points that don't align with established law or procedure.
I, David Howard, accept the oaths of office of all judges, county attorneys in this matter, the same creating indemnity bonds to guarantee that the public is not harmed by these actors. Bond of David Earl Howard. Letter of stipulation and understating. For the record, I am not a recipient of any bond of record to initiate the matter or answer the matter regarding case number 75C01-2311-F6-00157. That's the case we're in right now. And associated matters. Therefore, I am a man, David Earl Howard, state the following. This is my firm offer to pay and any and all costs lost by the court and representative citizens thereof in case number 75C01 to be 2311 F6 00157 to be determined by the appropriate officer of the court to indemnity the court and other respective actors. The amount of this undertaking to be determined by the judge of the court and entered by the clerk of the court for this bond to be properly credited. The amount to be filled in and this bond returned to the trustee maker for the proper accounting crediting payment. The court is requested to respond in 10 days presentment of this bond so that David Earl Howard has 30 days after receipt of the court to enter payment. The intent is to secure that this court and all respective actors are properly indemnified against any potential losses due to this action of David Earl Howard. Imus Sintis, with any understanding that this bond should ensure in lieu of arrest or detention of David Earl Howard due to raid, plaintiffs, or defendants by any injury pursuant to the general maritime law and applicable statute law in the form applicable contracts, none of which are to regard as waived or are specifically reserved. Bond order. Negotiate this item through the back office for settlement via the pass-through account David Earl Howard, SSN, and the QSIP number at the Treasury window, Department of the Treasury, 1500 Pennsylvania Avenue, Northwest Washington, D.C., 2220, for the settlement and set-off of case number 75C01-2311-46 or F6-00157. Zero in the account, set the account to not collect any further. A dishonor of the above bond is a violation of the National Bankruptcy Act. I got a jurat in the back. Using the notary, this document does not constitute any adhesion, nor does it alter my status in any manner. The purpose for this notification is verification and identification only, and not for entrance into any foreign jurisdiction. So here, I just read off to you this is the 5th time I've put in a bill of exchange to set off this account. The 5th time. This bond is bonding all involved, indemnifying all that are involved. That means there's no money left on the table is basically what that's saying. It's all been covered. So yet again, we are still here doing a trial for something that's already been zeroed out. I followed the Treasury rules on bills of exchange. I've entered it multiple times in multiple ways, but I'm not going to take up any more of your guys' time. I believe that legal tender has been made, and that's all I got for y'all. I mean, I paid it, legally paid it, set it off.
If your debt-setoff argument didn't work the first 4 times, what makes you think repeating it in front of the jury is suddenly going to change anything on the 5th attempt? At this point in the trial, things take a slightly different turn than usual, as the judge allows the jury to ask a few clarifying questions so they can better understand what's being presented on the record. This helps ensure everything is clear, structured, and properly addressed within the proceedings as the case continues.
Okay. Ready, Mr. Howard?
Yes, sir.
Question 1. What does he mean by zeroed out? Then it says, in parentheses, Stark County clerk. What does he mean by bonded out times 2? So let's start with the first one. What does he mean by zeroed out?
Right. See how do I put that in? By the Bills of Exchange Act, by the, I guess it would be the Treasury also, the United States Treasury, there is no legal money. Everything is ran off of a fiat system, debt system. When you tender payment, no matter if the intended trustee accepts it or not, your debt is discharged because it is an obligation of the United States Incorporated. So I paid multiple times, and I just went downstairs and checked. My account says 0. I am zeroed. So I have literally zeroed out my account already. It's in their own computers here in Stark County Circuit Court. Because once you tender payment, your debt is set off, which means it is zeroed out. There's no more to add to it. You know what I'm saying? I can't pay nothing for zero. You see what I'm saying by that? It is literally zeroed out. As in, amount owed, 0. Amount due, 0. There's nothing else to add to it because you can't add nothing to a 0. You see what I'm saying? Like, literally, it means your hands are clean, zeroed out. There's nothing left to do for it, for that account. So, I don't know. I can't get that on.
Okay, hang on a second. So is that your answer to the first part of the question?
Yes. Did I answer your question? Or
No,
do
you
need
can't
me-
ask some questions, sir.
Just forgotten.
Okay, so now listen to me for a minute. Hey, get off your phone, please, sir. I understand you may have notes or something on there, but not where you're testifying. Look at where it's at the table. So listen to me for a minute. Pay attention, okay? So now I would give the attorneys an opportunity to see if they have further questions based on the question you just answered, okay? So you kind of started this by calling yourself. So do you want to ask yourself an additional question based off of that one question?
Yes.
Okay.
Question I'd ask myself is, if it's zeroed, then what are we doing here?
Okay, so what's your answer?
I have to let the judge answer that one.
Oh, I'll answer that. But I'll answer it with a question of my own. If you're standing here in court, what exactly makes you believe your child support obligation has somehow been reduced to 0?
So,
All right, Mr. Poulos, do you have any questions?
Yeah, you mentioned something about going downstairs and checking something. What did you check?
my case
Okay, through who?
through the clerk's office.
Okay.
The computer at the clerk's.
Do you have any documentation stating that your child support arrears is zeroed out from the child support
I
office?
just looked at my case. Let me but I can't put it in evidence now, though. A little late.
Sir, you please put your phone away while you're on the stand, okay?
Can I show you? Yeah.
No, sir. I am not on the stand. I'm not in the middle of this. Okay. So the question is, what he's asking you, first of all, is where did you go look? Why did you go look? Because you're saying that there's a zero balance. And so clearly answer that, first of all.
I went down to the clerk's office and looked up my case, and that's why I needed my phone, because there was a certain bar I had to click on to see if the case had any, and it was in the field warrants. And
Sir, put the phone back up for the third time.
I was trying to answer his question, and I went and
I
looked,
wanted
and
to tell you about pulling your phone out there and stand. Stop, okay? All right. So now ask your next question.
Or what's your cause number?
75C01-2311-F6-00157.
Okay, so you looked at your criminal case, not your child support case.
Mhm.
So you don't know what your balance for your child support case is, though.
I have it wrote down somewhere
Okay.
on one of the affidavits I entered.
Okay, so your child support case does have an arrear. Is that accurate? Okay, I don't have any other questions.
Okay.
So, our Father of the Year candidate just spent a good stretch insisting he had a 0 balance on his child support, when in reality the only thing sitting at 0 was his understanding of his actual legal situation, because what he really had was a record tied to enforcement for not paying child support. It's a pretty classic misunderstanding of how these things work. With that cleared up, we can now move on to the second question from a jury.
So then the next question was, what does he mean by bonded out? And it says X2. So maybe that means 2 times. I don't know. You can interpret that however you want. But
Yeah, like I was discussing prior, when I was working, it was like maybe every 5 weeks, they would stop me, arrest me, and I'd have to bond out to get out of the jail. And that happened at least twice, I remember. And the first thing I did when came in last December was release those bonds to my children. And then that's when I started writing the bills of exchange and been going on for a year, going to court here and there. There's 3 times I couldn't have the trial, whatever, congestion. Every time I would write a bill of exchange to pay off this debt. And that's every time I would write another bill of exchange on my own, try to figure out how to, like I said before, stay in honor with the court, but also not degrade my new children's lives either. So the whole time I was just trying to reach an meeting of the minds that benefited all involved.
You didn't need a meeting of the minds to pay child support. You just needed to pay it in the first place. And once again, he keeps repeating the claim that he didn't use conventional payment methods because it would supposedly have put his other children in a difficult position. That reasoning keeps coming up as part of his explanation, even though the obligation itself remains unchanged regardless of personal interpretation. With that said, the discussion continues as the court proceeds with the next part of the process.
So then we go on to this other set of questions, and it's divided into 2 parts. The first part is you're claiming you attempted to make payments through the necessary channels and they did not accept it. They're saying, and it says he is not clear. So they're saying you're unclear about how you made the payments, what you used to make the payments. So explain how you made the payments. Are you saying they didn't accept them? Expound, please, on that. That's what the question's geared at.
Okay. I've filed at least the very first court case in December. I filed a conditional acceptance proof of claim that I was in the arrearage. They satisfied that. Then the trial didn't happen. Got moved again. The next time I filed another similar conditional acceptance stating that I will pay I think at the time it was $50,000 to cover any in the rearages in any court case. They didn't accept it. They struck it. So then, third time, supposed to have trial again, I filed another conditional acceptance with proof of claim. $50,000 again, backed by a 1099-A, which is a IRS document that is used to pull money out of your basically your legal fictions, your name, your social security number. I added that, and they still did not accept or deny, which I've already stated multiple times. That means the debt has been discharged. There is no debt in their own laws and statutes. And then the third time I completely wrote a whole different way. Basically, accepted for value, as in I accept it, but I had some conditions. I had some questions I wanted answered. Like, is it illegal to continuously harass someone for a debt? Now, another question would be, how do you pay when the Treasury of the United States says that the bills, notes have no intrinsic value? That's the type of questions I had on the last one. They struck that one also. So this time I wrote a bond indemnifying everyone involved, so there is no question it has been paid for a 5th time. So some laws that say that after the 3rd time something's entered, it becomes law. There's a lot of things behind these bills of exchange. And I've stated in honor with the state the entire time because I want to see a positive resolution for all parties involved.
Okay, so you expounded quite a bit on that. Is there any other questions you want to ask yourself, Mr. Howard?
No, sir.
State?
Did you ever go to the child support office and offer to pay in cash?
No,
Did you ever go to the child support office and offer to pay with a debit card?
I don't have one.
Did you ever go to the child support office and offer to pay with a certified check or money?
Nope, I don't have any access to those either.
Any more questions, Your Honor?
Okay, the second part of the question, Mr. Howard, and you may have kind of already answered this, I don't know, but is do you have receipts for these payments?
Receipts. Yeah, they're all filed into the court case.
Now, are you talking about what you just read to them earlier, your Exhibit A? Is that what you're talking about?
Yes, this and the other ones are all filed previously also.
But when you're referring to receipts, that's what you're talking about. They've already heard it.
Yes.
Okay. All right. Do you want to ask yourself any questions off of that, sir, Mr. Howard?
Nope.
State?
No.
Okay.
I wanted to let him finish his answer to the question before stepping in, but it needs to be clarified that an IRS Form 1099-A is not a method used to pay off debts. It's primarily issued by financial institutions in situations like foreclosure or repossession of property, not as a way for individuals to discharge obligations. The way it's being described here doesn't align with how the form actually works and could potentially lead to serious legal consequences if misused. With that clarified, we can now move on to the next question from the jury, which, in my opinion, is the most important one so far.
All right. So, Mr. Howard, here's the question. If there was no money exchanged, how was the debt paid?
Very good question. And it goes way deep. How do we begin this one? I guess if I'd start, first question is, what is money? Money, the little paper greenbacks we carry around? Or is that a debt note? Oh man, this is a hard one to discuss. Okay. The findings of our own Congress and our own Treasury Department is clear. So the findings of Congress and our own Treasury Department, Proclamation, what is it, 260 or 270, that cash, as we know it, the dollar bill, has no intrinsic value. It's not backed by gold or silver or commodities. It's all backed by the full faith and credit of the United States people, not the government, by the people. So, in essence, it is a fiat currency, which means fictitious currency. There's nothing backing it. So I cannot, in good faith, pay with a debt note, understanding that if I pay with that debt note, it puts the American people's debt up. It raises our debt. What is that called? The state debt, or the country debt. If you pay with using bills of exchange and set off, you're actually taking out the debt from the debt ceiling. You're moving it and completely zeroing out that count. So there's no more debt to raise in the debt ceiling. If you pay with cash, you're just keeping the debt system alive. Cash is a debt note. It has nothing but expressing that there's a debt owed. That's it. It does not set off, it does not zero, it does not alleviate the country's debt burden at all by using cash. So in my mind, I was saying, well, I might as well knock out the set off and help my countrymen by not leaving a higher debt for this country to have to swim through.
That's certainly a choice of explanation, but it doesn't change the underlying obligation. Not paying child support still creates financial hardship for the children involved, regardless of how the decision is justified. Framing it as contributing to broader financial goals doesn't alter the fact that the support payments were owed and not made as required.
14, this was in the preliminaries. I'm just giving it again. It's under the Constitution of Indiana. They're given the right to decide both the law and the facts. Any objection to that, Mr. Howard?
I object to all these jurors. None of them understand what a bill of exchange is. So this all going to be, it's more of an uphill battle for me to even outline the actual defense, which is tender payment, legal tender payment. So it's, man.
Okay.
I'm in a rock and a hard spot. You understand what I'm saying?
Sure. Number 14. The question is about number 14. So this is a pattern instruction that is kind of, juries have a right to determine for themselves what the law is and what the facts are, but they also can't ignore the law. And this is the instruction that articulates that principle. So my question is do you have an objection to that instruction, instruction 14?
No.
State?
No, Your Honor.
Okay, 14. 15 is unanimous. I'm sorry, hang on. Yeah.
But I have a question about number 14. Since it's talking about the laws, I'm going to have time to read over the Bills of Exchange Act and various things, right?
This is what we talked about earlier. I'm the one instructing them on the law. That's what we're doing right now. Is we're talking about what instruction of the law they're getting. These are their instructions.
So are you going to give them instructions on Bills of Exchange?
No, because one, it's not relevant to a criminal case, and two, you didn't provide me with an instruction. I would say this, sir.
I mean,
here's the problem here, and you need to think about this. These people understand how the world works, probably more so than we do. And they're going to make their decision based off of how they understand the world works, and what the evidence was and what the law is. So you've got your exhibit in. At no point in the proceeding have you brought up anything that is pertinent to me that would constitute a defense for this criminal thing. You've got out the facts for what you believe has been valid payment, but you also have the definitions here where you can make arguments based off of these instructions for defenses. So I'm not instructing them on bills of exchange or any of these other things. You have plenty of ammo to make whatever arguments are necessary based on everything that's happened up to this point in this case. Well, there's a guilty and a not guilty, right? And there's only one count.
There's only one count, so pretty much it's either they say yes to this or no to it. Right?
So I guess there's really three possibilities. They could find you guilty, they could find you not guilty, or they could hang.
They can't come to agreement.
Right, they can't come to a unanimous verdict. So these are the two possibilities where they fill out a document. If for some reason they hang, they tell us they can't come to verdict, and we come in here and there's other process. Okay, so any problem with the two forms of verdict?
And I was hoping there'd be different, at least the option.
You want a third option? What would the third option be?
That I accepted payment, or accepted the charges and paid it.
Well,
That would be the ultimate for me, being the one being accused.
well, that's included in not guilty, I guess. If they believe that, then they find you not guilty, sir.
Oh,
All right. So you make your arguments in closing, and then this is how it works. So have a seat. And then are they ready, Donna? All right. So go ahead and stand up, Rise. We're gonna bring the jury in.
Now we've finally reached the closing arguments. And to be fair, things are not looking great for the defendant at this point. I'm going to start by showing the tail end of the prosecution's closing statement, and then we'll move directly into the defendant's full closing argument, so you can see how he wraps up his case.
And based on the evidence, it's clear there is an arrearage, and the arrearage was never paid. In the child support payment, the arrearage is still there. He never made the payment. How did he pay? didn't use cash. He didn't use a check. Didn't use a debit card. Didn't use any of the ways that people pay for things. Mr. Howard just said he wrote something called a bond and sent it to the U.S. Treasury saying he's moving debt from one place to the other. That is not payment.
Objection.
I'm up here. Objection's overruled. Go ahead.
And based upon all the evidence that you've heard today in the testimony, I'm going to ask that you find the defendant guilty, non-supportive dependent child. Thank you.
Mr. Howard, now is your opportunity. You want the podium?
I think I will hold on to this all.
Okay.
This is one of the forms payment that I entered into on September 2nd, 2025. And there's a conditional acceptance, change in terms of agreement. Basically, it comes back to the same thing I just made legal tender of pay. Debt discharge into the statutes, codes, UCC is basically the commerce for the entire country, all the Western world, everyone that is like America, of course, they all work out. UC1 clearly states payment is tendered, set off, discharge happens week. At least 5 different bills of exchange I've sent in here to stop us from getting to this point at all. Understand I have rears, understand I have other kids, the obligation. After time, founded, now we're here a year later. In fact, stopping me every 30 days, every 5 weeks, until I started learning about law. And then the kidnapping had stopped, but I had to deal with this. But I learned way more about law than I ever thought I would. And I see there's still some things I need to learn. But I'm not here to debate whether I need to learn something. We're here to debate whether it's intentional or not. And I hold fast, never been an intention of mine to literally not pay support my grown kid. And pounded on me, and I got pounded. That many times I've already used legal tender the whole year, fighting them. Know that we go further. There's nothing else I can do except for do the whole legal debt note thing. Been trying to avoid that because that does not help our country's debt at all. It only compounds the debt, the national debt. I went the legal way and I wrote bills of exchange to set off the debt, reduce. It's not failed. You guys help direct court in the right direction.
So that brings the closing arguments to an end. And now the case is fully in the hands of the jury as they head off to deliberate. It only took them about 31 minutes to reach a verdict, which is surprisingly quick given everything they just heard. And honestly, if you stuck around this far, you probably already have a good idea of where this is heading.
Okay. You want to stand up or you want to sit down for me to read this, Mr. Howard?
I'll stay.
Okay. So the verdict reads as follows. We, the jury, find the defendant guilty of count 1, non-support of a dependent child, a level 6 felony. Signed, Robert Gilmore, the foreperson. I must go through here, starting with you first, ma'am. Is this your verdict?
Yes.
Is this your verdict, sir?
Yes.
Is this your verdict, sir?
Yes.
Sir?
Yes.
Sir? Ma'am?
Yes.
All right. And so say you all?
Yes.
Yes.
All right. You can have seats. Anything else you want to raise while you're here, sir?
I'm definitely appealing.
Well, so I got to sentence you first.
Yeah.
And so, and I'll just tell you that I'll tell you now while you're here. So when I sentence you, I'm going to tell you there's a certain time frame to file a motion to correct error or a notice of appeal. If you fail to do that within the required time frame, you're going to waive and give up your right to do that. Generally speaking, it's 30 days, and there's different. Once the sentencing order goes in, you pretty much have 30 days to do something. You have a right to ask me to appoint an attorney to represent you to conduct the appeal if you're indigent, and you also, of course, can hire an attorney. But here's what I would tell you: if you're going to do the appeal yourself, I would not do my own appeal. Okay, let me explain to you how hard it is.
Well, I've looked into that.
Okay, it's not easy. There's attorneys that's all they do, and there's attorneys like I was, where all I do is trials. And I would not ask an appellate lawyer to do a trial, and I would not ask a trial lawyer to do an appeal. If that explains to you how difficult both things can be.
Yes.
So are you planning on doing it yourself, or are you going to ask me to appoint someone to represent you?
I've looked into appeals. It is pretty complicated, but I still think I'm gonna go at it myself.
Okay.
Basically, the judge makes it clear that trying to file an appeal on your own in this way doesn't really change the outcome. It's essentially the same as doing nothing, just with a lot of unnecessary steps added on. With that addressed, we now move into the sentencing phase, where the court formally determines the consequences of the case, and we see the next stage of enforcement related to the unpaid child support obligation.
All right. So are we ready to go forward, Mr. Howard?
Yes.
Okay. So we're going to start off with the state first. Do you want to read your statement or start off with your argument first?
I'll read the statement, Your Honor.
All right. Go ahead.
Thank you, Your Honor. Your Honor, I'm submitting the statement regarding the sentencing of David Earl Howard, the father of my children, Hunter and Lily. Despite repeated opportunities to comply with his legal obligation, he has consistently failed to do so. He's significantly behind, and his non-compliance has continued even after prior court involvement and now a guilty finding. This demonstrates a clear pattern of willful disregard for the court orders and for the well-being of his children. As a result, I've carried a full financial and emotional responsibility for our children without reliable support. This has caused ongoing hardship, instability, and stress for them. His actions are not isolated mistakes, but a continued refusal to take responsibility, despite knowing the impact on his children and the consequences under the law. I respectfully ask the court to impose the maximum sentence allowed. Prior leniency and the court intervention have not resulted in compliance, and a strong sentence is necessary to enforce accountability, deter future violations, and protect the best interests of the children. Our children deserve consistency, stability, and support. I believe a firm sentence is the only way to address this pattern and ensure that the court orders are taken seriously going forward. Also, to revoke all hunting, fishing, and driver's license until arrears are paid in full. Thank you for your consideration. Respectfully, Jamie and mother of Hunter and Lily.
Okay. All right. Thank you. And then, so now we'll go to the argument of the state.
Thank you, Your Honor. Your Honor, Mr. Howard has limited criminal history, but he does have some. He has a prior OVWI, or driving while intoxicated, out of Texas, which I believe is a misdemeanor. And then he has a conviction for a felony for manufacturing and delivery of cannabis. That was a 6-year sentence with 2.5 years served, and the rest on parole out of Illinois. And then he now has this new conviction. Your Honor, with him having limited criminal history, but also the issues I know he's had with following the court orders, it is a interesting situation to be put in. I believe an appropriate sentence typically on these would be an 18-month sentence of probation with the requirement that he pay his child support and apply by all probationary measures. But at the same time, I don't know if he would even respect the orders of probation or any of the requirements that were made. At this point, Your Honor, he doesn't have a whole lot of aggravating factors other than this is technically a victim case, and he does have some criminal history. But at the same time, the mitigating would be that he has limited criminal history, even though one of them is a felony that he did have to serve executed time on at the Illinois Department of Corrections. The biggest concern here is to make sure he's paying his child support. That's what's needed for the children, and also help him eating out with all their expenses. As of right now, I believe he's currently in arrears of $29,081.30 as of February 11th of 2026, with his last repayments coming on September 9th, 2024, for an income withholding order December 23rd of 2024, which was from his bond that he posted for his March 6 release in this case. And then the March 1st, 2025 was for a tax refund payment. So at this point, Your Honor, he still isn't making payments. So I believe that based on prior cases or similar cases to this, I believe an 18-month sentence of probation with the requirement that he abide by all probationary rules, as well as maintain and make a steady payment of his child support, is appropriate this time, Your Honor. Thank you.
This part of the sentencing is a bit unusual because the mother of his children is requesting jail time, while the prosecutor is instead recommending probation. Even the judge appears somewhat taken aback by the differing positions being presented, as the court weighs very different outcomes for the same set of facts.
Okay, so the mother of the children wants me to send him to prison, but you want me to put him on probation.
Yes, Your Honor, it's the balancing act of mitigating and aggravating factors, also with the concerns of the victim. I believe the big issue here is getting him to pay. If he doesn't pay, or if the court decides otherwise, completely understandable. But I understand she wants him to go to prison, but I still have to act within accordance of the mitigating and aggravating factors of, resolving his criminal history. He scored low on the IRS risk level assessment. Doesn't have any delinquent behavior. It's a non-supported dependent case.
What does that have to do with anything?
No, I was just listening what the case was.
Okay.
It's just difficult to balance what the appropriate sentence should be in this circumstance. Beyond that, if Ms. Eaton would like to make an additional statement, if the court would allow so, she can. But
all right, let me hang on. Are you done with your argument?
Yes, Your Honor.
Let me just ask Ms. Eaton. You have a right as really, you technically, I guess, would be the victim's representative, because it's really the children that are the victim in the case, because they're the ones that are owed the duty of support. You have a right to make a statement. Would you like to make a statement outside of what's been read in court?
Oh.
I'm going to go to Mr. Howard now. So do you want to call your witness? Do you want to make your argument first? How do you want to start this?
So let her come in first so she can read.
It's Ms. Cager.
Yeah, it's Ms. Cager.
All right, bring Ms. Cager in here. Ma'am, you're going to come right up here to this chair, okay?
What we were talking about in the car, so I got to talk about.
Mr. Howard wants to ask you some questions, and then I guess the state will have an opportunity to ask some if they want. Go ahead, Mr. Howard.
Who's basically raising our 3 kids now?
Well, he stays home with them and I work.
So
he is full-time staying home with them and I work full-time.
Basically that's what I was saying. That's pretty much what I would have
Sir,
said too.
just let her. So, ma'am, you're here for a reason.
Okay, yeah. I have just one thing I don't understand.
Just hang on a second. Just hold on for 1 second. So you're here because you want to say something on Mr. Howard's behalf, right?
Okay, yes.
So what do you want to tell me in making my decision on how to sentence him?
I just really don't understand the $30,000 thing. If you break that down into 18 years, that's $1,600 a month. I've breastfed and cloth diapered all my kids. So I've not spent nearly that much a month.
Ma'am, so let me slow you down a little bit here. So we had a trial where there was evidence presented and the jury, not me, came to a verdict. So we're past the guilt phase. So what we're at here is a sentencing phase where I have to make a determination of where in a specific range up to 30 months in prison to sentence Mr. Howard to, and how that sentence should be effectuated, right? So getting in some factual argument about the underlying facts of the offense is not going to be productive.
Okay, I just don't know what I'm supposed to say, I guess. So that's why.
So that's why I'm at. So is there anything you want to say on his behalf?
That he raises our kids full time, I work full time. So yeah, if he goes to prison, I'm going to have no job, lose all our stuff. Yeah. So is that what you want me to say?
I don't want you to say anything other than what the truth is, man.
It's the truth.
He brought you here.
Yeah, if he goes to prison, then our kids will have no dad, and I will have no job. We don't have anybody else to watch our kids. He is the only one. I don't have babysitters, or even can't even afford a babysitter because they're outrageous.
On top of the legal arguments, there's also a noticeable lack of self-awareness being pointed out here, because she's raising concerns about the exact situation that the defendant allegedly put his ex-wife and children through. Adding another layer to the situation, it's mentioned that she is also pregnant with a fourth child, which further complicates the circumstances being discussed. At this point, the financial strain already outlined in the case makes the broader situation even more difficult to ignore.
Are you okay if I ask you a couple questions?
Yeah,
The pre-sentence investigation made it sound like you were pregnant. Are you pregnant?
I am.
Okay, and that's with his child?
Yes.
Okay. And that's due around May or June?
Yes.
Okay. And then the other question I have is the pre-sentence investigation also indicated in the last 3 years, Mr. Howard's been doing concrete work?
He has periodically, yes. Like when I was not working, either had the babies or whatever, he does side work.
Okay. All right.
And we have made payments during those times. Because I am the one who physically goes and does it.
You're the one that makes his payments?
Yes. To make sure it gets done, yes.
Where do you work at, ma'am?
Aldi.
Okay. All right, Mr. Howard, do you want to ask her any other questions?
She knows that every day.
Sir, it's a
every
yes or
day.
no question. 'Cause I gotta let that-
You're good.
Every day, you know, I love my kids and that I understand that I've never had a life with the two, you know.
You're gonna have an opportunity to say what you want to say in a minute, sir, but do you have any more questions for her?
No.
No.
No. Mr. Poulos,
Nothing additional, Your Honor.
are you okay?
Yeah. Got something in my eye. I'm okay though. Thank you.
Okay. All right, ma'am. So you can go back out there with your children. Thank you. Okay. So now's your opportunity to, one, make your argument legally what I should do based on our laws. And then two, you can make, your statement before you're sentenced about whatever you want to talk about. Now's your time to go ahead and do those two things.
Well, like my witness said, I watch my kids every day, 3 kids all day, every day. And most days of the week, she don't do it all day, every day, but and I love my kids now. I couldn't find it when I was younger, I guess. I don't know. I never got the connection with my other kids, and maybe that's how it went off. I don't know. I never meant to not pay. I never intentionally thought about it, not doing it. I made sure it was set up at work that way and still got off somehow. And, I intend to find something out for work-wise. I've been doing a lot of research into our banking system, our whole system, and I'm looking for employment. Through that means by educating myself, and I'm not gonna be able to do that if I'm locked up. There's no way for that. Just be stuck in the same cycle of non-payment to my other children, which is not fair to them or me. I see the errors that I've made, and I don't plan on making them again. And the own federal code just says once a debt has been satisfied, it is considered offset. So I was going on that those codes.
So you still believe you don't owe this back child support?
Well, I mean, if you don't accept, if the bills of exchange aren't accepted, I guess I do. I don't know how that works through the courts.
And now you got to explain to me why you put in there that you do not believe this is a crime and then it's BS.
For what?
In the pre-sentence investigation.
I don't recall that. Because I was still going on the same assumption of the code that once a debt has been satisfied, the bill of exchange promissory note, that the debt was discharged.
Well, your wife, she works at Aldi, right?
Yeah.
And I assume they pay her with money, right?
Yeah.
Okay, and then you take that money and you guys buy food?
Yeah. Yeah.
So you eat, right?
I do. Well,
You don't go around with these letters you make up and buy groceries, right?
I mean, that's a whole different ballgame. You're talking like trust and courts and grocery. It's
Sir, this isn't a game, right? You're obviously not starving to death, right?
right.
Okay, and your kids aren't starving to death, are they?
No.
So you guys are eating, right? And don't you think the children you have with this other woman deserve to eat too?
I do.
And don't you think you have the obligation to contribute to that?
Finally, the judge drives the point home with a simple but effective example. Money is used to buy food, so it stands to reason that the same money should also be used to meet child support obligations so that all children involved can be properly provided for. At this stage, it feels like the arguments have run their course, and everything important has been said. With that in mind, the proceedings now move forward into the sentencing phase.
All right. So, obviously the jury returned a guilty verdict for you on this count. I'm accepting their verdict, entering judgment of conviction. What I have to look at is the sentencing criteria in 3538 1 7.1, looking at the aggravators and mitigators. In aggravation, you've got this felony conviction out of Illinois with a 6-year sentence from 2012 and a prior misdemeanor for driving while intoxicated out of Texas. Also in aggravation, I find some of the statements you made in the PSI. You deny being behind on your financial obligations in the PSI. You don't believe this is a crime and said it was BS. I have no idea why you put in there that you were working for the past 3 years, although maybe your wife kind of explained this, that she would make periodic payments for you. And I have no reason to disbelieve that based on the evidence that I heard in the case. In mitigation, you've got prior military service where you were honorably discharged. You have your current girlfriend, wife, whatever terminology you want to use, and these 3 kids with a 4th on the way that you're supporting. And that's something that I have to look at under the statute, that you have these minor children that could be negatively impacted depending on what I do here. And for some reason, you came up with a low risk to reoffend. That's based on, this risk assessment they do. And, I'm going to be perfectly honest with you, Mr. Howard. If you keep on going down the road that you're going down, I would say Miss Cager is probably going to get tired of you. Just like probably everyone before that got tired of you. You kind of did all this to yourself. Nobody likes to go to work. To some extent, most people would like to just kind of hang out and not do anything, but you can't do that. That's just not the way that the world works. And although you may disagree with the way the financial system works, it's a lot better than going around with a bag of potatoes, trying to trade a bag of potatoes for a horse and all this other stuff. We just all have agreed that we're going to use this green paper as a universal way to trade things back and forth. And whether you agree with that or not, that's just how it works. And if you even look at the statute for non-supportive dependent, the definition of support doesn't even include the word money. It doesn't say anything about money in there. It's about the children having food. It's about the children having medical care. It's about the children having the things that they need to be children that have their needs met. And you could provide those things through in-kind things, but you didn't do that. You didn't provide money either. So we have a mother of these 2 children left in a situation where she's footing the bill entirely, when under our laws, you're required to contribute. Part of me really thinks putting you on probation would somewhat be a waste of time. But I'm hoping it's not. I'm hoping everything that's happened up to this point has made you realize that this is serious, that you need to do what you need to do, and it's really kind of the only way that I can help out your other children and your current children, because it's clear to me that Miss Cager is probably going to be worse off if I send you to prison. But you need to understand this. If everything you say here today is a lie, there's a very strong possibility, if there is a probation violation, you will leave me with no other choice than have you serve the sentence I'm getting ready to impose in the Department of Correction. You understand that, sir?
Yes.
All right. So here's what I'm going to do. I'm going to sentence you to 24 months and 8 days. You have 8 actual days of credit. Or I'm sorry, 16 days, because you get day for day credit. 24 months and 16 days.
You have 8 actual days of credit. You get day-for-day credit since this is a level 6 felony. So the remainder of that sentence, the 24 months, is suspended. That suspended sentence is placed on probation. You're ordered to follow all the terms of probation.
Alright, so that's where we're going to wrap up today's video. The judge goes on to read out the terms of probation, which are fairly standard in cases like this, laying out exactly what's expected moving forward. But if we're being completely honest, the real question is whether there's any real intention here to actually comply with those obligations, especially when it comes to child support. So ultimately, time will tell whether this is a turning point or just another pause before things end up right back in court. If you made it this far, let me know what you think down in the comments. Do you believe giving him probation was the right call and a chance to do right by his kids? Or do you think this is just delaying the inevitable and setting things up for another return to court? Either way, that's going to do it for today's video. If you enjoyed it, make sure to like, subscribe, and I'll see you in the next one.